Hey KM, welcome to our show. We chose one of the most significant cases of all time, the New York Times versus the United States. Hope you're gonna like it.
The background to the New York Times versus the United States case is deeply rooted in the context of the Cold War. Post World War II, the world was divided into two blocs: the Eastern Bloc, led by the Communist Soviet Union, and the Western Bloc, led by the United States. This period of time was recognized with many proxy wars and geopolitical tensions. By 1954, the Vietnam War became a hotspot in the Cold War. As North Vietnam, backed by the Soviet Union, fought South Vietnam, backed by the United States and other anti-communist allies, as both powers fought to extend their influence over the world.
Nixon, go home! Nixon, go home! Nixon, go home! Stop the bombing! Stop the bombing! Stop the bombing!
The military U.S. involvement in the Vietnam War, driven by the desire to stop the spread of communism amongst the nations under the domino theory, escalated over the years, leading to mass protests and controversy in the American people. As war progressed, the American society grew increasingly divided on the U.S. role. And as the number of casualties rose and the media coverage showed the true realities of the war and the brutality of it, the anti-war sentiment was fueled and the controversy went bigger and bigger. The war left a scar on American society and politics, and debates are still ongoing today on the justification of the involvement and its consequences.
So I want to tell you a little bit about the background and the material facts. In 1967, the Secretary of Defense, Robert McNamara, created the Vietnam Study Task Force. He wanted to investigate the involvement of the United States in Vietnam between 1945 and 1967. For the purpose of writing it, thousands of military officers and historians were hired. The study, titled as The United States and Vietnam Relations from 1945 to 1967. The study, which was completed in 1969 and included more than 7,000 papers, document the treatment of four presidents during the Vietnam War. So now I'm going to tell you about Daniel. A young man named Daniel Ellsberg worked in the RAND Corporation. The RAND Corporation was the company who did the research and the study. In one of the days, he gains access to one of the copies of the study, and he decided to read the copy. After he read that, he decided that he had to inform the public about the government controversial decision during the war. As he said, when he read the papers, he saw that a number of military officers and presidents violate their oath of allegiance. So, with the help of his friend Anthony Russo, he started to copy all the documents. And in 1971, while he was a senior research associate in the MIT University, he met Neil Sheehan. Neil was a journalist of the New York Times, and Daniel decided that he will give him the copies that he did with Anthony. And just like that, in June 13, 1971, it's my birthday, please remember it, in June 13, 1971, the first chapter of the documents was published, and the reaction of the President of the United States, Richard Nixon, was very upset.
Oh my God, oh my God. Who published this? Did you see the front page? No, this is absolutely outraging. I need this to be canceled right now. We need to stop the publication. Oh my God, oh my God, oh my God.
He considered the publication as a violation of the national security, and he ordered the administration to issue a federal order to prohibit the next publication. And just 5 days later, in June 18, 1971, the Washington Post decided to publish the documents as well. And if I want to do like a little, to sum up a little bit, so the case New York Times versus the United States is a civil case, and the government wants to prevent the New York Times and the Washington Post from publishing information that they are that they title as top secret.
Just 2 days after the New York Times began publishing the Pentagon Papers on June 13th, 1971, the U.S. government, cites national security concerns, sought to prevent further leaks, securing federal injunction from the U.S. District Court for the Southern District Court of New York. On June 18th, Judge Murray Griffin heard the case and, guess what, denied the government's request for an injunction.
Your Honors, the publishing of those papers will put both of our troops and our national security in danger. You have to grant our request for injunction.
So we have discussed your request and we decided to deny it. Injunction denied.
Now, you're probably asking yourself, well, what did the government do? Well, I'm here to tell you. The government appealed the Second Circuit Courts of Appeal, which reversed Griffin's ruling, granting the government's request for an injunction against the New York Times. This led to a temporary halt of publication while the case was under consideration.
Your Honors, this is an urgent matter. You have to accept my appeal and grant the request for injunction.
So your appeal is accepted and your injunction is granted.
Now, in the midst of the battle, the Washington Post also began publishing excerpts from the Pentagon Papers, similar to the New York Times. The Post faced immediate legal challenges from the government. Now, the Post's involvement added another dimension to the case, reinforcing the issues of press freedom versus national security concerns on a broader scale. Well, obviously, as a result of these developments, the New York Times immediately appealed the Second Circuit's decision to the U.S. Supreme Court. The Post case, which had also been moving through the courts, was combined with the New York Times case. The U.S. Supreme Court heard the arguments for both newspapers in a hurried manner, starting on June 26, 1971. During this time, the court also ordered a temporary halt on further publications of the Pentagon Papers by both the New York Times and the Washington Post, which this led to intensifying the stakes of the legal battle and setting the stage for a landmark decision on the extent of press freedom under the First Amendment. The U.S. Supreme Court, guess what, ratified the New York Times request to deny the government's request for an injunction. Now, we're moving on to our legal issue, so let me ask Maya. Maya, what is our legal issue of the case?
Thank you, Ella, for asking. Our legal issue here is, does the government has the power to impose restraints on the media to prevent publication of classified information? And now I will explain about it a little bit. In the United States, the freedom of the press is protected by the First Amendment. Any violation of this freedom is generally not permissible. But, and there is a but here, the there are times that the freedom of the press and other freedom are conflicting with other significant interests. And in those situations, the courts may permit restrictions on the media, such as national security, public safety, defamation. This limitation must meet the strict legal standards to overrule the freedom of the press.
Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Your Honor, we have to inform the public. This is not a national security concern.
In the pivotal Supreme Court case, the New York Times versus the United States, the decision, with a 6-3 vote, favored the New York Times. At the heart of the ruling lays the powerful principle of the First Amendment, which in this case was tested against immense pressures on national security. The ratio decidendi revolved around the concept of prior restraint. Prior restraint is a concept where the government tries to prevent the publication of information, documents, or anything like that due to concerns of national security. This court rationale was that the government has the obligation to prove beyond doubt that the publication of the information will lead to a severe and direct harm to national security, a burden that in this case the government has failed to meet. The court asserted a strong presumption against any action that preemptively prevents the press from releasing information, emphasizing that such actions are generally unconstitutional. The legal reasoning underscored the delicate balances between national security concerns, and upholding the freedom of the press, acknowledging the public's right to know, and especially in matters of the government's actions, transparency is vital. Justice Harlan dissented. She argued that the case should be remanded to assess dangers rather than making an absolutist ruling against prior restraint.
Okay, guys, what did we learn for this lesson? The New York Times versus the United States. It's a landmark case, and it affects the freedom of the press all around the globe, even until this day. First, this case is a great example of breaks and balances. Show us that the government does not possess limited power, even when they scream national security as an excuse. If they have a weak case, it doesn't mean the judicial branch will bow to their will. The Pentagon Files case is a big win for the press and a great loss for the government. Obligated the government to act in transparency while they know that their decision-making process can be public knowledge at all times. From our eyes, this case is a great victory of the small guy over the government, some kind of a modern David and Goliath, even when the stakes are high and much to lose also for the government itself. The Supreme Court's decision in New York Times versus the United States had a critical and far-reaching ramification for legal jurisprudence and the landscape of press freedom all around the world. By ruling against the use of prior restraint in this critical First Amendment case, the court set a powerful precedent, limiting the government's ability to censor the press and hide the bar to make it happen. The decision emphasized the importance of a free press in a democratic society, establishing the high standards for any censorship of any press. Now, to our days in Israel. It's related exactly to the days of the war, when we see publication of our troops movement in primetime TV, when we see our soldiers looking for tactical equipment all around the media, and everybody can see it, even our enemies. We see footage inside Gaza Strip in real time. All of this can raise some questions of how can they publish it and if it doesn't concern our national security. But at least partially thanks to the Pentagon Files case, Now everybody can do it.